Stuart Nash.
Mr Chair, I would just like to pick up on what the last speaker was talking about, but also what Mr Scott alluded to. He said that the main connection in the clause at 156A1 is very easy because it's where the heart is. But Mr Chair, when we were in the Select Committee, this is where the problems really arose, because obviously where the heart is not a definition at all, but the concern that the Labour members had is that often it is not where the heart is, but perhaps where the wallet resides. and so what we actually did, Mr Chair, is we asked the IRD to go back, as well as our expert advisor, to go back and provide us with a number of examples on how this might work in certain circumstances. And the IRD, to their credit, obviously, they came back with a whole lot of examples which laid out main dwelling. But I suppose my point for relaying this story, Mr Chair, is it is not an easy test. And Mr Robinson pointed out that members in this House are often very much in the same position. I mean, we spend 3 or 4 days a week in Wellington and 3 or 4 days a week in our home electorates. We could claim, theoretically, that our main dwelling is in Wellington because the one that's owned in Eketahuna is not worth nearly as much as the one in Wellington. So I'm just saying there that there is the possibility for a little bit of moral hazard. And I would like to also talk about what Julianne Genter was discussing in her supplementary order paper. The point she made was actually quite an interesting point. She said, if you only have to give your IRD number on the 3rd time you do this, then why would you do it? Well, the simple solution to that, well, the simple answer I've got, Mr Chair, is because that is the law. And under the law, you have to do it. But what it does introduce, Mr Chair, is a level of moral hazard that if everyone says, well, you know, it might be the law, but you know, I travel at 55 k's in a 50k zone, it doesn't really matter. It might be breaking the law technically, but it doesn't matter. Then what you actually end up with, Mr Chair, is a piece of legislation that doesn't meet the intended purpose. Now, we just think that it is quite easy to remove that moral hazard. And there's something called the Sale and Purchase Agreement. It's a standard agreement. It's actually put together by the Auckland Law Society. And they're in the middle of a review process at the moment as we speak. And we discussed this with the IRD, we discussed it at Select Committee. We thought it would be very easy just to add in a field IRD number. And there's about 10 or 12 different clauses in this agreement, Mr Chair, and you just tick the box for IRD number and you enter it in. And it just removes any sort of moral hazard and it removes any complexity. And the reason I say that also is because the Minister herself stood up and said, well, we want to remove complexity from legislation. We want to remove complexity from the whole process of buying and selling property. And I found that slightly interesting, Mr Chair, because there is something called Land Information Online, and it is acknowledged actually as one of the top pieces of land transfer software in the world. New Zealand is rated usually 1st or 2nd in the world in electronic transactions. As it is at the moment, Mr Chair, every land transaction that occurs in this country has to be registered online under the Minister's own department. So what we're not doing here, Mr Chair, is asking for added complexity. In fact, I would argue the opposite. What we're actually doing is removing a level of complexity by asking people to make a choice or a decision around whether they have to provide an IRD number or not. We just say, let it be compulsory, let's make sure everyone has to provide an IRD number, then there are no questions. There's no instance of moral hazard, there's no complexity. And when we talk about complexity, I would like to come down to section 156D, and this talks about emissions and errors. And I have a couple of concerns here, because what it seems is we're getting into the intent test yet again that I think has bedevilled a little bit of the whole capital gains, do we or don't we have a test in this country. Now obviously we have to have a clause in the legislation which governs emissions or errors of information. Yes, Mr Chair, it is. It's 156D, emissions or errors. And what it says here, an omission or error must be corrected, and you know, we may, that's true, but 156D Part 2, it says and this is where I'm slightly perturbed. It says an emission or error in any, so this is 156D2, an emission or error in any tax information, Mr. Chair,
Certainly.
Mr. Chair, provided in accordance with sections or any other failure to comply with sections 156B does not, so it does not affect the validity of any registration of an instrument to transfer a specified estate in land. So what this is actually saying, Mr. Chair, is if there is an omission or an error, then the contract is still binding. The contract is not void. And I've come across this before in other land information where what is happening with overseas investors, for example, is they're just doing things retrospectively. But where it gets a little confusing for me, Mr. Chair, is if we go down to 156 E, it talks about false or misleading tax information, and it talks about it defines what is actually false or misleading, and it says to that person's knowledge or with intent to deceive. And I wonder if that should be and, because I don't know if you could actually have an intent to deceive without having that person's knowledge, if you know what I mean. So what I'm saying here is if you have an intent to deceive, then you are doing that with knowledge. And this is where I come back to, I'm jumping around a little bit, but it's still in the omissions and errors, where it talks about omissions and errors. To me, there's a difference between an omission and an error. And for me, Mr. Chair, an error is something that is done, how do I say this? without malice, without intent. Whereas an omission, I would argue, is actually done with, intent. So an error demands, it denotes a mistake. An omission perhaps implies something more sinister. So actually, Mr. Chair, I would have liked to have seen 156D2 just talk about an error, and then 156E talk about an offence to provide false or misleading information, and an omission included under there. Because I actually think an omission is a proactive action as opposed to just a general mistake. But the interesting thing, Mr. Chair, is it talks about the fine for committing misleading information, because we're keeping in mind it doesn't affect the validity of registration. So the fine for committing an error does not exceed $25,000. Now that sounds, I know on the face of it, $25,000 sounds like a lot of money, Mr. Chair. But in essence, when we're talking about large-scale property deals, even if we're talking about buying a house in Herne Bay or, a single dwelling in Auckland, a $25,000 hit, if you make a false or misleading information, however, the deal still goes through, and I assume this is governed by the, what's that piece of the contracts administration, anyway, so what you could actually do, Mr. Chair, and again, it comes to that moral hazard, you could say, you know what, I'm going to provide that misleading information or false information. I'm going to take the hit for $25,000. It'll go through, I'll pay the fine, and then what I have to do under this Act is go ahead and correct that information. So I'll do that, but the $25,000 hit is actually worth it. And what happens, Mr. Chair, is if an investor provides false or misleading information a second, third or fourth time, that fine increases to $50,000. Well, I should say it doesn't increase, it does not exceed $50,000. So again, we may find that $50,000 for jaywalking be hugely excessive, but $50,000 for providing false or misleading information when we're talking about a high-end property deal in a place like Auckland or even a tower, I mean, this isn't defined to just residential property, is actually a price that people are prepared to pay to get that deal to go through. And I actually would have, in this case, and I'm pretty liberal on this, but I would have liked to have seen those penalties be a lot harsher. And the one thing I really would have liked to have seen, Mr. Chair, is in fact, for false and misleading information, that the deal is automatically void. So what it really does is it deters people from entering into that sort of moral hazard of providing false or misleading information, but taking that hit, which I think is actually quite important. We have had a number of speakers talk about main homes, and again, we come down, I just want to come back to this because it is important and it did take up an inordinate amount of the committee's time. and a main home register. I think Julianne Genter's supplementary order paper is in essence talking about this. But where the confusion arose, and I think where the...
I'll call Grant Robertson.
Thank you,